The Perry Chain Company manufactured bicycle components, and in 1956 they employed 18-year-old Marlene Withers on one of their assembly lines. Her job required her to manually handle parts covered in grease, and this grease gave her dermatitis, so she was unavailable to work for weeks. The company found her other work which did not involve handling parts covered in grease. Those parts had been treated with machine oil, but had then been through a drying process which was expected to remove most or all of the oil. Nevertheless, dermatitis still required her to take time off work. Eventually, the employer found her still other work involving no contact with grease at all. She sued her employer for negligence in relation to the dermatitis that she'd suffered in the second position. The employer clearly had a duty of care, but the court found that the duty required the employer to take all reasonable care, and by transferring her to a more suitable position, the employer had done this. They therefore found that the employer was not liable. Lord Justice Sellers went one step further, in a sense reminding us that the law is always a human endeavour, because from his judgment he was quite clearly concerned in large part about Marlene Withers' ingratitude for the efforts of her employers. He said, "There is no duty at common law requiring an employer to dismiss an employee rather than retain him or her in employment and allow him or her to earn wages because there may be some risk. The duty of the defendants in this case was to take all reasonable care for the plaintiff in the employment in which she was engaged. Applying that standard, the evidence in this case does not establish any breach of duty. The plaintiff had the advantage of her wages and her employment in circumstances in which every consideration was given by the defendants in order to assist her. And I add that it seems to me a little lacking in gratitude to bring this action against her employers when she has had the advantage which she sought to obtain." From this case, we learn that even where a duty of care exists, the duty of care is to take all reasonable care, or as the law now says, to do what is reasonably practicable. There is no duty to eliminate risk altogether.